Well, good evening, everyone. Let's go ahead and get started. We have a few more people just who will be joining us and are trying to log in, but let's go ahead and get started. Welcome and thanks for joining us. My name is Tracy Austin, and I'm the Director of Alumni and Community Relations at Colby-Sawyer College. And we're thrilled to have a nice group of alumni, students, parents, faculty, and staff and friends with us online this evening. I'm especially pleased to have Professor Eric Boyer online with us for this webinar titled, Does Our Constitution Protect Fundamental Rights? Professor Boyer has been teaching at the college since 2008, and his areas of expertise include American Studies, government, history, and philosophy. Now, before I turn things over to Eric, I'll just a quick review of the format for this evening. So we are recording this presentation and we'll share that recording link with you in the coming days. Because this is a webinar format, the microphones and video feeds for all of you in the audience have been disabled. If you're having difficulty seeing or hearing us, please send us a message in the text chat and we will do our best to help you through that. Professor Boyer will plan to make a presentation and will immediately follow that with a question and answer session. You may type your questions into the chat box or use the Q&A function. And we'll track those questions as they come in and we'll do our best to get to as many of those as possible tonight. Just as a reminder, the chat and Q&A functions can be found at the bottom of your Zoom screen. So just use your mouse or touch your mobile device and those icons will appear at the bottom of the screen. So with that, I am ready to turn things over to Professor Boyer. Thank you very much.
Thank you so much, Tracy, and thank you to everyone who is taking time out of an evening to come and hear me talk about fundamental rights in the Constitution. I especially appreciate that because of the changes to homecoming, I'm not competing with Mountain Day, which is normally what I'm asked to do on the in-person homecoming. It's always hard to compete with Mountain Day, so now I'm just competing with a cold Tuesday night. So I feel like I have the advantage in this format. What do I want to do today? I want to try to talk. I want to give some context and try to give you a bit of background about some of the big, exciting, dangerously interesting cases that are going before the court in this particular term. No matter what your political persuasion, this is going to be a session of the court that will be worth watching because many hot button issues are coming before the court. I want to try to provide context because it's very tempting when confronted with the court, especially a court that is going to tilt very conservative, to explain away what the court is doing by simply saying, oh, it's a Trump appointee, or it's an Obama appointee, or it's a Bush appointee. And while that certainly is an element here, I want to try to provide a bit of the background, a bit of the context that will allow you to understand some of the workings going on in this. So Tracy is putting the outline for tonight's presentation in the chat right now. I apologize for not having a PowerPoint that I can share with you. I'm going to blame this on my 2-year-old, Wesley, who decided this morning to get a stuffy nose and a drippy nose, which meant he could not go to childcare, which meant my wife and I were balancing the day. So at the time of day where I was going to make a PowerPoint, I was wiping noses, which is, I feel like I say that more and more with my 3 children. I was going to do this, but instead I was wiping noses. So my apologies. The outline for today is basically to give just a little bit of an introduction. There is a really fun history to this issue, and a history that I'm surprised we don't tell more. So I want to dip my toe in that history a little bit before getting into the substance. So we're going to dip my toe in the issue of fundamental rights and the really fascinating history at the founding. Then I want to just give a really quick overview of 3 different ways to read the Constitution, because this is going to be one of those really important points that we don't all read the document the same way. And you and I can look at words in the Constitution and come up with radically different ideas about what those words mean. Once we looked at this little brief history and we look at 3 ways to read the Constitution, then I want to get into a very quick but hopefully thorough look at how the issue of fundamental rights was treated in the 20th century. Because some of the most famous and or infamous cases arise in the 20th century over this question. And then once we look at the 20th century, I want to ask, why does this matter, right? Who cares if something is a, quote, fundamental right, or if it's just a right? right? Well, it matters, and I want to talk about why it matters, because this label, this particular formulation, is incredibly significant for the court. I want to do that, and then I want to take a brief look at cases that are before the court, specifically on two issues, on the issue of abortion and the issue of gun rights. And then after that, I will hopefully have plenty of time for questions and discussion in any way that the audience wants to take the conversation. So just a quick aside, I'm always trying to figure out in kind of late summer what might be interesting in mid-fall for homecoming, and I try to think of a topic or a title that will be interesting no matter what twists and turns politics may take. And so I put my finger on probably the world's worst title for this one. Why is it a terrible title? Well, honestly, to answer the question, the answer is just yes. Okay, now we can end the webinar. We're done. Yes, of course the Constitution protects fundamental rights. So what is the topic actually about? What is the talk actually about? It's not really whether the Constitution protects fundamental rights. Everyone that reads the Constitution could agree that it protects fundamental rights. The question really becomes, what are these rights? Right? Because we can both agree that the Constitution protects fundamental rights. But if you believe that a woman has a fundamental right to terminate a pregnancy in the first trimester, and I believe that that is not a fundamental right, well, then we're going to disagree about whether the Constitution protects this particular right. Right? So the question, does the Constitution protect fundamental rights, is not quite what I want to ask. It is, what are the rights that are fundamental, and how do we find them, and how does the Constitution protect them? So first, just really quick, I indulge me for a moment on this fun little history about the Bill of Rights and fundamental rights. I want to take you back to the summer of 1787. Now imagine it is August, early September. It is swelteringly hot in Philadelphia. And you, along with about 50 other people, give or take, people are getting sick, people are going home, people are riding late, maybe around 40 at this point, wool-clad, mostly old men are sitting in a swelteringly hot room in Philadelphia. The curtains are drawn to maintain secrecy. There is no airflow at all, and you would just really want to go home. By this point, the convention has been going on for months. Everyone is sick and tired of discussing this new Constitution. Everyone is looking forward to going home, and it's at this moment that George Mason of Virginia asks for the floor, and he demands that the convention discuss attaching a Bill of Rights to the Constitution. Now, I'm sure you're thinking right now, well, of course, the Bill of Rights is one of the most sacred parts of our political doctrine, or how could we not want to debate a Bill of Rights? Well, at the time, in that late August, early September in Philadelphia, this request was met with a groan at best. Why? Well, immediately people jumped on Mason and said, how can we possibly do this? How can we possibly figure out which rights to explicitly protect? It's late, George. We all want to go home. This is simply going to delay this process for even longer. But a more interesting, I would say a more in-depth critique was actually lodged by Alexander Hamilton. And it speaks directly to this issue of fundamental rights. Hamilton objected to the idea of a Bill of Rights not out of convenience or not out of timing. Instead, he objected because he was worried that if you start to list particular rights that are protected, you would do two things. First, the government is not allowed to violate these rights, Hamilton said. Hamilton said, look at the Constitution. Why on earth would you need to explicitly protect the practice of religion? Where in the Constitution does the government have the power to restrict your religion? Why would we possibly have to prevent the establishment of a religion? Where in the Constitution do you see the power for Congress to create a religion? So Hamilton was worried that a Bill of Rights would unnecessarily worry people, right? Oh my gosh, you're telling me Congress can't do this. I didn't even know you were thinking about it in the first place. That it would just create panic. And it would give people the mistaken impression that this is a very expansive, overly powerful government. Whereas Hamilton was kind of ticked off at this point because he didn't think the Constitution was doing enough to create a powerful centralized government. And he definitely didn't believe that it had the power to do these things. that the Bill of Rights was going to stop it from doing. But the second objection is that the moment you start listing specific things, what do you do with the things that you don't list? This is a major concern. The moment you start picking specific rights that you will name in the document, and keep in mind, initially, Madison was going to go in and insert this language into the Constitution. It wasn't going to be, attached to the end. It was going to be, track changes, right? Like edited directly into the document. Hamilton was worried that if you start naming specific things, you're not going to name every single right that Americans have. So what do you do with the stuff that goes unmentioned? And these critiques by Hamilton carried the day, which is rare for Hamilton. Most of the things Hamilton wanted, most of the times he harumphed and complained about something, he was basically ignored. But this one stuck. And so there was no Bill of Rights in the initial draft of the Constitution. But this quickly became a problem. Why did it become a problem? Well, most states at this period of time, in the late 18th century, most states had a Bill of Rights, some articulation of your basic freedoms, things that the government cannot do. I like to put it this way, a Bill of Rights says these certain issues are being taken out of the political realm. No matter how big the majority is, no matter how fervently the majority wants to do this, they can't. Right? So these are the things that are being taken out of the political process. Most states had these. So anti-federalists, those who did not want the Constitution to be ratified, they saw their opening and they thought, okay, here it is. This is our issue. This is our rallying cry. Because the anti-federalists were a lot of different types of characters. Some of them were debtors, right, who were worried that this new central government would override paper money laws in some states. Some of them were rural backcountry farmers that were worried about an overly distant central government. Anti-federalists were a whole rainbow of types of interests that were against the Constitution, but they could rally around this one central lack, this one central deficit, and they did. They started just hammering the Constitution relentlessly in pamphlets, in speeches, in letters, hammering the convention for not attaching a Bill of Rights, essentially saying to the potential ratifiers of the Constitution, hey, what are they hiding? What are they going to do? They didn't even have the courage to protect your rights. This was a problem for the nationalists who wanted the Constitution to be ratified. And so by the time we get to Massachusetts in the ratification march, this is a problem. Fun fact, one member of the Constitutional Convention, Elbridge Gerry, who did not sign the draft because he was opposed to it, got into a fistfight with a defender of the Constitution in the Massachusetts ratifying convention. Francis Dana and Elbridge Gerry tried to beat the crap out of each other during the ratifying convention because of this issue. Gerry really believed that a Bill of Rights was absolutely necessary. Francis Dana thought this was a distraction. So what comes out of Massachusetts? What comes out of Massachusetts is this big compromise, right? And this compromise says, okay, those of you who are nervous about a Bill of Rights, ratify the Constitution, and we will attach a list of amendments that we will insist Congress takes up and considers in their first deliberative sessions. This is a compromise, right? Because the anti-federalists want to say, do not ratify until there is a Bill of Rights. The compromise says, ratify, and then we'll consider a Bill of Rights. This was an incredible act of political faith. I mean, in this era where right now even Democrats don't trust each other, right? Different members of the Democratic caucus are at odds with each other and don't trust each other. This was an incredible act of faith, because if I am nervous about a Bill of Rights, I am essentially saying yes to this radically new system of government with the hope and expectation that it will turn around and limit itself to protect my rights. But it works. This compromise gets just enough people in Massachusetts to say yes, that Massachusetts ratifies. Then the same kind of compromise emerges in New Hampshire, right? And now we get to Virginia. This is the home of George Washington, the home of James Madison, and the home of Patrick Henry. And Patrick Henry is a vocal, obnoxiously opinionated enemy of the Constitution. Madison and Henry go toe to toe in an epic, I think, 3-week showdown over the Bill of Rights. Patrick Henry with his gigantic personality, his booming voice, and then poor little 5'3", reedy voiced James Madison defending the principles of the Constitution. And Patrick Henry really sees this Bill of Rights issue as an opening, and he just presses it and presses it and presses it. And Madison, who was very skeptical about a Bill of Rights, he essentially said, what is a piece of paper going to do? If the government wants to violate rights, mere parchment barriers are not going to prevent it. He just thought it was a distraction, but he comes to see it as a political tool. A Bill of Rights, what does it do? It doesn't really limit the government because the government can't do the things that it's protecting against. But what does it do? It alleviates concern. So Madison says, okay, if you ratify the Constitution, I will go to Congress and I will submit a list of amendments that will be considered by the first federal Congress. And by the barest majority, I believe it was 6 votes, and it had more to do with access to the Mississippi than on anything about, political freedom or Republican liberty. Virginia says yes, right? And imagine for a second if Virginia had not said yes, if this had not gone this way. I mean, George Washington is not our first president. Now all of a sudden he can't be because Virginia is not a part of the Union. So just a fun little history, and then it gets even better. And I apologize again, humor me, this is fun stuff. Patrick Henry is not done yet. He sees Madison has made a promise. Madison promised, you ratify the Constitution, I will go to Congress and I will propose amendments. So what does Patrick Henry do? Like any good politician, he gerrymanders Madison's district. This is before Elbridge Gerry became the father of the modern gerrymander, right? This is years before Elbridge Gerry decides to manipulate boundaries. What does Patrick Henry do? He puts Madison in the same electoral district as James Monroe, super popular James Monroe, with the hope that James Monroe would out-campaign Madison, win the House of Representatives seat from that district, and then Madison wouldn't be able to propose amendments, and then the whole constitutional agreement would crumble, and people would call for a new convention, right? Fun fact. So Madison has to come back to his district. He has to campaign. He hates campaigning. He has to go on election day and give a speech and get people drunk, which is what you did back during the founding. You'd feed them. You'd make a speech. People would get really, really drunk, and then they would vote for you. And Madison hated this, but he had to because James Monroe was really popular and squeaks out a win, goes to the Congress, proposes 12 amendments. 10 of them make it out of Congress. And then those 10, 12 of them make it out, all 12 make it out of Congress, and 10 of those are ratified as the Bill of Rights. So where are we with this idea of fundamental rights? The entire history of the Bill of Rights is wrapped around this question of what do we do with rights that are not explicitly mentioned? And so there are 2 parts of our Bill of Rights that speak to this, but neither one is very helpful. So as I move through my talk today, I'm going to keep using what I affectionately tell my students is the beast, my constitutional law textbook. So forgive me if I'm looking down at my text as I'm going through these sections. But the 2 amendments that speak to the issue of fundamental rights are the 9th and 10th Amendment. The 9th Amendment states, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So they're explicitly saying, hey, just because we're mentioning certain things in the Bill of Rights, that doesn't mean you don't have things that are not listed. And then Amendment 10, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Okay, so clearly there is this thing called fundamental rights. Clearly our amendments are not a full listing of rights. And just because something's not explicitly listed doesn't mean it's not protected. Yes, but you quickly hit the point where you say, okay, but wait, but what are those rights, right? So the 9th Amendment is telling us there are these other things. There are these other rights that are retained by the people, but it doesn't tell us how to find them, right? It doesn't tell us a method for determining what those rights are. And then the 10th Amendment says, yeah, the states should have power unless this is granted to the national government. But there are clauses in the Constitution which essentially give the Congress the right to do almost anything it wants. The power to regulate commerce and the necessary and proper clause effectively nullify the 10th Amendment. There is almost nothing that is not delegated to the United States by the Constitution when you read the Commerce Clause and the necessary and proper clause, especially when you read it the way the Supreme Court has read it, which is to allow almost anything to be taken over by Congress. I like to tell my students, desegregation of the South did not come from a part of the Constitution pertaining to liberty or equality or dignity. It came from the Commerce Clause, right? So much of our progress as a nation is thanks to Article 1, Section 8, Commerce Clause. Article 1, Section 8, the third paragraph, right? To regulate commerce. So we haven't really gotten very far, right? Why does this question persist? Why are we still in 2021 trying to interpret a question that was first brought up in 1787? It's because our Constitution winks at, alludes to the fact that there are these fundamental rights, rights that they didn't feel the need to explicitly protect, but it doesn't give us a roadmap to find them. So we've been debating, we've been contesting whether or not something's a fundamental right. So then this moves us to, how do we read the Constitution? And I want to try to do this quickly. I realize I've spent 20 some minutes on my dipping a toe into the history. I'm long-winded. But how do we read the document? I just want to look at 3 possible ways of reading the document. And I want to emphasize these 3 because these are the 3 methods that are present on the court right now. The first, and by far the most popular way of reading the Constitution on the court right now, is originalism. And originalism states that the Constitution should be read as a text. Now, what does that mean? What that means is words mean what they meant to the people who wrote and ratified the document. So, for example, a phrase like the right to bear arms, or a phrase like cruel and unusual punishment, a phrase like to regulate commerce among the states. What does that mean? An originalist would say, what did it mean to the people who wrote and ratified the document? Why? Why this group? Because this is the group that democratically ratified the document. An originalist would say that the legitimacy of our Constitution comes from this democratic moment of ratification. It was a time in which the people drafted, debated, discussed. Elbridge Gerry and Francis Dana got into a fist fight over it, but then they ratified it. And so the words mean what those individuals believed that they meant. The moment you stray from that rigid meaning, you are undermining democracy, and you are inserting the personal preferences of judges in for the democratically legitimate language of the founding. Okay, so when you want to know what words mean, you pull out your dictionary from that time period. So if it's the first 10 amendments, Blackstone's dictionary of 1790, right? What do these words mean? If you don't like the definitions, change them by amending the Constitution. If you are not able to get a Democratic majority big enough to amend the Constitution, to an originalist, that is further proof that you should not be allowed to reinterpret the text, because you can't even get the requisite majorities to agree that this is what the text should mean. Okay, so for an originalist, the Constitution should be read as text plus history. If the text does not explicitly protect a right, where do you look to see if it exists? You look at the history of the United States. Is there a long, uninterrupted history of honoring that right? If there is, winner, you found a fundamental right, right? You found a right so fundamental, so taken for granted, that the framers did not feel the need to explicitly protect it. But the only way you will find that is if there is a long, uninterrupted history of honoring that right. Okay? 2, the moral reading. The moral reading is in many ways the opposite of originalism. The moral reading emphasizes the vague, open-ended, explicitly moral language of the Constitution. The moral reading states that this Constitution is filled with moral language that is left intentionally undefined and not narrowly construed. It is a text that demands our interpretation. It requires our interpretation. To approach it as simply a collection of words is to have an incredibly narrow, poverty-stricken idea of what this text is. It's so much more. It's not an anchor that drags us down. It is a framework, it's a guide that evolves with us, and it allows us to explore new ethical terrain, new vistas of freedom that would be completely unavailable to the framers. So for a moral reader, we are constantly bringing ethics and morality and conceptions of justice to bear. And we don't need to look for a long, uninterrupted history of honoring a right. In fact, the Constitution is oftentimes brought in to undermine a long historical precedent of prejudice and discrimination. So for the moral reader, the Constitution is text plus ethics, right? It's not a text plus a long uninterrupted history, it's text plus ethics. Finally, we have what's called pragmatism. And pragmatism starts from the premise of, let's stop talking about constitutional theory. We don't need more theory, right? We don't need more theory, we need more emphasis on consequences, facts, and evidence. So a pragmatist is going to be oriented around, how do we solve the problem that's presented to us? And how do we solve a problem in a way that can get us as close to consensus as possible? That can, if it means incompletely theorizing an agreement, that's perfectly fine. Oftentimes, our agreements that achieve consensus, they achieve consensus because we don't try to go too far away from the issue. We narrowly decide a case to try to solve problems. And we as judges should ask, who is hurt? Who is helped by this? Right? How will this decision impact people in their daily lives? They're more likely to bring in social scientists, criminologists, sociologists, political scientists. They're not really looking to hear from philosophers or historians. They want to hear from social scientists. So for a pragmatist, the Constitution is text plus consequences. Right? Now, these are not rigid silos. It's not like if you're an originalist, you never care about consequences, or if you are a pragmatist, you never care about ethics. No, but these are general guideposts for reading the Constitution. So what does our court look like? Well, if you are a conservative, take heart, because it is a 6-3 conservative majority. And of those 6 conservatives, 5 of them have explicitly identified originalism as their guiding philosophy. So on the court right now, Justice Thomas, Justice Gorsuch, Justice Alito, Justice Barrett, and Justice Kavanaugh have all explicitly embraced a version of originalism. John Roberts, our other conservative leaning judge, is not explicitly an originalist, yet he dabbles in originalism. He frequently is looking for the original meaning of text, but he's sort of an originalist mixed with a pragmatist. He's very concerned about the court's legitimacy. And many are wondering whether or not Kavanaugh is going to be more of a pragmatist than originalist as well, because with the court the way it is now, Kavanaugh is your swing justice. Now, Kavanaugh is the most middle of the road justice, and he is not middle of the road. So the real question will become, where does Brett Kavanaugh stand on most of these issues? Because where he stands, the court will often stand. So on the other side, the 3 left-leaning justices, you have 2 really clear moral readers in Justice Sotomayor and Justice Breyer. And then you have Elena Kagan, who is a pragmatist who leans towards the moral reading. I like to think of her as like moral reading curious, right? She is a pragmatist. She's very concerned, very attentive to consequences, but also would be leaning more towards a moral reading than the very narrow originalist meaning. So if this is how we read the Constitution, right? Is it text plus history? Is it text plus ethics? Or is it text plus consequences? I want to give you a really quick example. Really quick example of this on the issue of gay marriage, right? So in the case Obergefell v. Hodges, the case in which the Supreme Court said that you have a fundamental right to marry, right? Originalists, as I'm sure you can expect, did not agree with this. They claimed that this was a ridiculous stretching of the notion of privacy, because it's based on the idea of privacy that the court arrived at this fundamental right. They look at our history and say there is not a long, uninterrupted history of honoring gay marriage. In fact, there is the opposite. And so there is no fundamental right. There is no fundamental right to marry in their eyes. You don't have a fundamental right to marry more than one person, right? So you don't have a fundamental right in their minds of marrying a person of the same sex. And so to them, this was a wrong decision. A moral reader would see this as an absolute instance in which a prejudice of a previous generation is being overcome through the ethical realization and ethical awakening of the American people. And that this is exactly what the Constitution was designed to do, to expand and grow with us. The Constitution is not, an article of clothing. We wear the same jacket in 2021 that we wore in 1787. We've grown, we've become better, and the Constitution stretches and grows with us. And that this is exactly what the court should be doing, using this moral document to liberate people and to protect rights that previously were not seen as worthy of protecting. And then finally, a pragmatist just sort of strips this issue down to some basic questions of who is hurt by gay marriage. There is this wonderful, if you're a pragmatist, exchange between Judge Richard Posner and I believe it's the Solicitor General or I believe it's the Attorney General for Wisconsin, who's trying to defend Wisconsin's gay marriage ban. And Posner just destroys it. And he says, name one person who's hurt by a gay couple getting married. No one, right? The only thing that's hurt is this vague tradition, which is meaningless. Halloween is a tradition, as he famously says. We're not going to restrict people's rights to honor the tradition of Halloween. So a pragmatist would ask, who was hurt? And they would answer, really nobody. Well, who was helped? A lot of people. And so that becomes an easy decision for a pragmatist. So fundamental rights, long, complicated history, right? Going back to the founding. The quest for fundamental rights is one of the fundamental issues that pushes justices to develop these theories of interpretation. And we have these three theories present in the court right now, and that is going to be very relevant when we look to cases going on in this term. Well, then how has this issue of fundamental rights looked over the 20th century? Why is a claim about fundamental rights so incredibly controversial? Well, I want to go back to the text of the Constitution, and I want to specifically look at the 14th Amendment, because the debates over things like abortion, well, specifically abortion and gay marriage, are about the 14th Amendment. And so I want to just quickly read to you the relevant section of the 14th Amendment. And it is, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So we have this claim, you as a citizen, you have due process, and you get equal protection. Well, those two issues they may seem straightforward, but that language is exactly the kind of open textured language that can be either narrowed by an originalist or expanded by a moral reader. And the first time that this case really, well, actually the first time is in Dred Scott v. Sandford, but that's a separate discussion, separate issue. In the 20th century, the first time this language really rears its head is in the case Lochner v. New York. In Lochner v. New York, New York was trying to regulate the hours that bakers could work in bakeries. If you don't know how disgusting bakeries could be in this time period, read Marx's Capital Volume 1, just specifically the section on the working day. It's pretty disgusting, the amount of stuff that is in your bread because the bakers don't even get time to use the bathroom or go home to sleep. So they're sleeping on their tables, right? Sweating and bleeding into their tables in the bread. It's disgusting. New York is trying to take on what they see as a public health issue. And so they start regulating the hours of workers. Well, owners of bakeries sue and take this issue all the way up to the Supreme Court. And in an infamous decision that has since been overturned, the Supreme Court throws out these regulations of working hours. Why? Right? This is interesting because these laws were passed by the legislature of New York following the due process of making a law. Everyone in New York everyone eligible to vote had an equal right to pick the representatives making this law. So where is the due process violation? How could you possibly say that these bakery owners did not have due process? Well, here we go. The court says the statute with limiting working hours necessarily interferes with the right of contract between the employer and employees. The general right to make a contract in relation to his business is part of the liberty of the individual protected by the 14th Amendment of the Federal Constitution. The right to purchase or to sell labor is part of the liberty protected by this amendment. So what is the court doing here? The court is doing something incredibly controversial. The court is saying that the due process clause of the 14th Amendment doesn't just guarantee you a process. It protects certain rights that are so fundamental to liberty that violating them would undermine the entire document of the Constitution. What rights are so fundamental to the idea of liberty that to not protect them would undermine explicitly protected rights of the Constitution? Well, in Lochner, the court is claiming that your economic right to negotiate for your labor is one of these rights. You have economic rights to negotiate in a, quote, fair and equal way, right? They're ignoring the power dynamic between, owner and worker here. You have that right. And when the government comes in and says you can only work these hours, you can only work for this wage, you can only work in a factory deemed safe, they are violating your fundamental right to negotiate for your labor. Incredibly controversial decision. This very conservative court, which is very keen on protecting the fundamental right to economic rights, becomes a real pain in the butt to Franklin Delano Roosevelt, who wants to really restrict your individual economic rights in the name of giving Americans a new deal, right? A new altering of the power dynamic between owners and workers. And so eventually, Roosevelt manages to put immense amounts of pressure on the court to get one justice, right? We went from 5-4 court defending economic rights. Eventually, one justice flips, and now the court becomes a 5-4 court undermining economic rights. The court disowns the Lochner decision, and the Lochner decision becomes kind of a stand-in for any time the court wants to say that their fellow justices are reading too much into the Constitution. For example, in the gay marriage decision, I believe every single dissenter at some point, with the possible exception of Justice Thomas, says the court is doing the exact same thing here that they did in Lochner. They are reading rights into the document that don't exist. So Lochner is this kind of first blast of fundamental rights, but it doesn't last long. The next discussion about fundamental rights happens in 1925. And this is in a case called Pierce versus Society of Sisters. In this particular case, there is a law that says you must send your kids to public school. You must send your kids to public school or you will be fined. Well, parents that wanted to send their children to a Catholic private school sued. and arguing that this statute violated their fundamental right to educate their children, their fundamental right to raise their children. And the court agreed that you have a fundamental right to raise your children. So from this decision, it says, they say, under the doctrine of Meyer v. Nebraska, previous decision, we think it entirely plain that the Act of 1922, mandating public education, unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control. The fundamental theory of liberty upon which all governments in this union repose excludes any general power of the state to standardize its children by forcing them to accept instruction from public teachers only. The child is not the mere creature of the state. So in this case, the court is saying you have, as a parent, a fundamental right to educate and instruct and bring up your children. This was a right that was so fundamental, so assumed to be a part of liberty that they did not feel, the framers did not feel the compulsion to explicitly protect it. Okay, one more, and that is the case Griswold v. Connecticut. This is the granddaddy of all fundamental rights cases, because it is here that the court determines the existence of this right to privacy. And it is this right to privacy that takes us from a case about contraception, Griswold v. Connecticut, to abortion, from abortion to sodomy laws, from sodomy laws to gay marriage. And so it is this right to privacy that puts us on a path that leads to the decision of the court in the Obergefell case on legalizing gay marriage. So what is the issue at play before the court? Well, in the state of Connecticut, it is illegal in 1960s to use contraception. Now, it is illegal to prescribe it. It is illegal to give advice on obtaining or using contraception. It is a law that most people in Connecticut don't even realize is on the books. It is a law that is essentially never enforced, but it is. In this moment, it is. And once the law is enforced, you now have a party that has been harmed by the law. And so now they can bring a suit. And what we get is Griswold v. Connecticut, a challenge to this statute that makes the using of contraception illegal in the state of Connecticut. The reason why this case is so incredibly pivotal for our understanding is, I'm going to do the work for you here when I ask, is there a right to use contraception in the Bill of Rights? Spoiler alert, no. No, it's not there, right? Okay, so the only way you're going to say, the only way you will be able to say that the state of Connecticut is violating your rights by outlawing contraception, the only way to make that stick is if you can show that your right to use contraception is in some way a right that is fundamental and not explicitly protected. That's not easy to do. So what does the court do? Well, the court does three things, right? I love this decision. In the majority opinion, this is the official majority opinion from Griswold, the court says that you have a right to privacy. Now, how do we find this right to privacy? We find this right to privacy in what they call peripheral rights. And what they mean by that is the explicitly stated rights, the freedom to practice your religion, the freedom to possess a firearm, the freedom to not have your person and papers searched, the freedom to not have soldiers quartered in your home. All of those rights depend upon an understanding of privacy. Without privacy, those rights become all but meaningless. And so we don't need to explicitly protect privacy because it is protected throughout the document. They call these peripheral rights, or in an even more clunky phrase, the penumbras of the explicitly protected rights. So let me read from the majority opinion here. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. Various guarantees create zones of privacy. Who needs theology when you have constitutional interpretation? I mean, we have penumbras who are emanating from zones of privacy. Oh, I love this stuff. So what's happening here? If you read the document as a total document, right? This is pure moral reading. This is pure moral reading. If you read the document as a whole, you will see that the document assumes a foundation of privacy. Because without privacy, these rights that are explicitly protected become meaningless. The court, though, has a rather narrow understanding of what privacy means. In fact, the real issue that the majority has with the Connecticut law is not the ban itself, but with the method of enforcement. They speak very rarely about the actual ban, but they go on at length about how destructive the method of enforcing this ban would be. Let me quote again here. Would we allow the police to search the sacred precincts of marital bedrooms for telltale signs of the use of contraceptives? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with a right of privacy older than the Bill of Rights, older than our political parties, older than our school system. So the court really has a problem with this law that can only be enforced by violating the quote marital bedroom, a specific location where you should expect privacy, right? Why is that significant? Well, it's significant because that's a narrow understanding of privacy. Privacy is a right you enjoy in a physical space that should not be searched without a clear and compelling interest by the government. But that's not the only opinion that was produced in the Griswold case. The Griswold case actually produced 3 different opinions, the majority opinion, and then 2 different concurring opinions. And the concurring opinions are kind of fascinating because the second concurring opinion says there is this fundamental right to privacy, but we should locate it not in these penumbras that are emanating from zones of privacy, but instead in the 9th Amendment, in that gloriously vague 9th Amendment that said you have these other rights that don't need to be explicitly protected. And in this concurring opinion, Justice Goldberg says, in determining which rights are fundamental, judges are not left at large to decide cases in light of their personal and private notions. Rather, they must look to the, quote, traditions and collective conscience of our people to determine whether a principle is, quote, so rooted there as to be ranked as fundamental, right? So what is Justice Goldberg doing here? He's kind of doing originalism. He's saying, well, is there a right to privacy that would be encompassed by the 9th Amendment that would give us pause about this contraception ban? He says, yeah, right? There is a deep, uninterrupted history of Americans honoring and protecting their privacy, especially over a physical space that where they would expect to be free from government intrusion. So we have the majority opinion. It's looking at a moral reading that's kind of like looking at the document as a whole and finding these implicit rights. Then we have a concurring opinion that says, no, we agree this law is a problem, but we're arriving there through a deep historical look, a very originalist look. And then there is the Justice Harlan concurring opinion. One justice, right? These other opinions are signed on by multiple justices. One justice, Justice Harlan, says, I agree with the outcome, but I don't like the way you arrived there. Justice Harlan wants to do something kind of radical. Justice Harlan wants to say that your right to privacy is not anchored in these penumbras, and it's not dependent on a long interrupted history of honoring that right. Instead, he says, in my view, the proper constitutional inquiry in this case is whether this Connecticut statute infringes the due process clause of the 14th Amendment, because the enactment violates basic rights implicit in the concept of ordered liberty. While the relevant inquiry may be aided by resort to one or more of the provisions of the Bill of Rights, it is not dependent on them or any of their radiations. The due process clause of the 14th Amendment stands, in my opinion, on its own bottom. What is Justice Harlan saying here? Justice Harlan is using a Lochner argument to defend privacy. Remember, in Lochner, the court said that you have this economic right that is so fundamental to ordered liberty that it cannot be violated, or it can only be violated with the absolute most pressing of governmental needs. What Justice Harlan is doing here is placing privacy on a similar foundation. Why is this relevant? This is relevant because it is the Justice Harlan concurring opinion that is going to be the basis of our notion of privacy. This is just fascinating to me because you have 9 justices, right? A majority of them want to frame privacy in a very narrow way. It is one justice that says, no, maybe we should have this really expansive, open-ended conception of privacy. And what you find is that over time, the court moves towards Justice Harlan's concurring opinion, much to the horror and chagrin of originalists like Justice Rehnquist and Justice Scalia. Oh my gosh, these case histories are replete with Justice Scalia, gnashing his teeth at the ever-expanding conception of privacy. But it's really because we've embraced this really open-ended understanding of privacy. It doesn't come from like penumbras and emanations. It doesn't come from a long, uninterrupted history. These would be very narrow confines for privacy. Instead, it comes from this very open-ended, open-textured reading of the 14th Amendment. And so why does this matter? Let me go to why does this matter? And then I want to look at the current term of cases. Why does this matter? And this is hopefully going to answer a lot of questions about how the court, hopefully answer questions about how the court navigates this issue. Just because something is labeled a fundamental right doesn't mean the inquiry stops there. Not at all. The courts are consistently violating your fundamental rights. But what does it mean? If a fundamental right is implicated by a law, if there is a law that is limiting one of your fundamental rights, either a fundamental right that is explicitly listed in the Constitution or a fundamental right that we determine exists, even without clear language, right? So if a law impinges on a fundamental right, or if it impinges on a, quote, discrete and insular minority, then that law is going to be subjected to what the court calls strict scrutiny, which is the highest level of scrutiny. The court is going to be incredibly skeptical about the law, and a law will only be determined constitutional if there is a compelling interest that it is advancing, and the law must be narrowly tailored to achieve that interest. These words mean a lot if you are a lawyer before the Supreme Court, right? So if there's a fundamental right implicated, the court is going to ask, is there a compelling interest that the state is trying to advance? And is the law narrowly tailored to achieve that interest? If a law does not impinge on a fundamental right, or if a law does not impinge on a discrete and insular minority, the court will use a test called rational review. And under this lower level of scrutiny, a law will be considered constitutional if there is any, quote, legitimate interest that is being advanced, and if the law is, quote, rationally related, right? Rationally related. So now all you need is a legitimate interest and a law that is rationally related, as opposed to a compelling interest and a narrowly tailored law. Okay, let me get to the current term, and then I want to take your questions. So the two big issues that are coming before the court that speak to fundamental rights are cases on abortion and cases on the right to bear arms, specifically the right to carry concealed weapons in the state of New York. So first, abortion. The court is right now hearing oral arguments on Texas Bill SB 8, which is a 6-week ban on abortion and has this novel, I would say, if we're being neutral here, a novel enforcement structure where no state actors are involved in enforcing the law. Instead, private citizens sue those who, I guess we could use the language of aid and abet abortion. This was specifically designed to keep the Supreme Court from intervening. We can talk about this if this is interesting to you. It's a very procedural question. It is a rather potentially terrifying way of crafting a law because I am of the opinion that this same structure could be used to undermine any one of our rights. If we can just have private citizens collecting bounties for restricting it and the courts can't get involved, well then what's your favorite right? I could imagine a state passing a law restricting that. But in December, the court will be hearing a law from Mississippi which bans abortions at 15 weeks. This is significant because in the 1973 case Roe v. Wade, the court said that a woman's right to terminate a pregnancy pre-viability is a fundamental right. And it is a fundamental right that is encompassed by your right to privacy and your right to make decisions about your family. So do you see how the Roe case, the Roe decision, rests upon these two fundamental rights that arose in the 20th century? Your right, we see it in Pierce versus Society of Sisters, your right to raise your children, your right to make decisions about your family, and your right to privacy. Up until the time of viability, this is a medical decision. It is not a decision pertaining to human life. After viability, the Roe court creates this trimester framework to try to make room for this idea that as a fetus develops, it becomes a rights-bearing individual. It has emerging interests, right? It has emerging interests that become compelling over time. And so in the first trimester, it is the woman's right to make this decision unimpeded. But in the second trimester, and then especially in the third, the rights of that unborn child are emerging. And as they emerge, the courts have more and more of a role, and the Congress, the legislature has more and more of a role in regulating the procedure. This case was challenged in 1992 under a conservative court. But that conservative court, in a decision known as Planned Parenthood versus Casey, upholds the right to an abortion, upholds this right, and says we are affirming the precedent in Roe because it would undermine the legitimacy of the court if we were twisting and turning on our precedents. If we in 1973 say you have a fundamental right to an abortion, right, and then not even 20 years later say, oops, never mind. People orient their lives around their expectations of their rights, so argues the court. This is now a settled precedent that women are orienting their life decisions around. It would be destructive to the court's legitimacy if we turned around and reversed our previous decision. What's fascinating about this, right, is the way that the court understands the right to privacy. Now remember, the right to privacy way back in 1965 was this narrowly understood right to not have your marital bedroom searched. But now listen to what has happened under Justice O'Connor. And Sandra Day O'Connor was a conservative justice. But now listen to what privacy means, okay? These matters, abortion, involving the most intimate and personal choices a person may make in a lifetime, choices central to personal dignity and autonomy, are central to the liberty protected by the 14th Amendment. At the heart of liberty is the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. Wow, right? I mean, that is a huge expansion of the idea of privacy. And it's fascinating that this conservative justice has adopted the most thoroughly moral reading understanding of privacy from Griswold, of the three choices available, picked the most expansive understanding of privacy. And so even as the right to get an abortion is being restricted, because it is being restricted in Casey, they are saying that all of these restrictions Pennsylvania is passing, those are fine, right? You still have a right to get an abortion, but now there could be waiting periods, there could be parental consent involved, there could be all these restrictions, right? What's interesting about this case is even as it is restricting your right to an abortion, it is radically expanding our understanding of privacy. So what is at stake in this decision coming in, the arguments coming in December and the decision in June? Well, if you're an originalist, you have been raging against the decision in Roe since the decision in Roe. I don't know that there is a world in which of these 6 conservative justices, you're going to get 2 of them to break with a deeply held distrust of the Roe decision to defend the main holding in Roe. The only question is, are Roberts and Kavanaugh pragmatist enough that they will emphasize the consequences for women of taking this right away, right? No matter what they think about the original meaning of the text and what the framers thought, because clearly the framers were not protecting abortion when they wrote the 14th Amendment, right? There's no history to show that. Are they pragmatist enough to say that this would be so disruptive to the lives of women that the court must honor this precedent? Another way to put it is, has the Roe decision become itself a part of our historical legacy that now needs to be honored by these 2 originalists? That's the only way I see Roberts and Kavanaugh. And again, they can do a lot of things and not officially overturn Roe. And I think, I think that's what they'll do. They won't say, hey, they're gonna say, hey, we're not overturning Roe. We are just limiting it to the point where it is essentially gone, right? And that states will be allowed to limit it into the fact to a point where it's almost impossible to get an abortion. That's most likely what is going to happen. And I'm happy to clarify, discuss further those cases. The gun rights case is fascinating because here we have, if you're a historian, you're going to eat this up because you have 2 dueling histories. The question before the court. So in the, I think it was 2002 decision of DC versus Heller, the court said the right to bear arms, according to the people who wrote this amendment, this was Scalia's masterpiece, this decision. This is his originalist magnum opus. The right to bear arms codified a right to self-defense. So what does that mean? It means you as an individual have the right to bear arms, not connected to your service in a militia, not connected to your service in any kind of armed forces. Now, this was a interesting historical study that Scalia undertook. Some sources were certainly emphasized, other sources were de-emphasized or ignored to get to this idea that the framers as a whole believed that you had an individual right to bear arms. But this idea now is Supreme Court precedent. You as an individual have the right to protect yourself with a firearm. So now the next question becomes, is this right confined in any way to a physical space? Is this a right you have only in your home? Or is this a right you have everywhere you go? So the case before the court is there a fundamental right to carry a concealed firearm in public? The reason why this case is so interesting is because both sides of this case are attempting to construct an originalist argument, right? And this is why I love this case so much, because everyone now knows that originalism is the currency of the court. If you want to convince the justices of the validity of your case, you better know originalism. You better be steeped in the history of the 1780s. And so the pro fundamental right to carry a concealed firearm side is saying that you have this deep, uninterrupted history of peaceable armed travel where you were allowed to have a firearm for self-protection no matter where you were going. You didn't have to justify any kind of threat. This existed in rural areas and in cities, in your home and outside of your home. And they are appealing to a variety of historical sources to try to make this claim. The other side, the side that is defending New York's gun control legislation, is pointing to an extensive history of not just New York, but the entire United States, regulating the traveling of citizens with firearms in public. And so it is going to be a duel between two different understandings of our history. Each one of these histories is pertaining directly to the issue of fundamental rights. Does our history point to an uninterrupted history of honoring your right to carry a concealed firearm in public? Or does our history show that this fundamental right does not exist and that we have extensively, throughout our history, regulated the possession of firearms while traveling? So again, those two cases really show the currency that originalism has right now, in that both of them are originalist cases with originalist arguments. So that is where I wanted to stop for right now, but I wanted to open things up to questions, a conversation. I'm willing to go where the audience wants to go.
Well, great. Thanks, Eric, so much. We do have some questions that folks submitted beforehand, but we have some questions as well that folks have put in the chat in the Q&A. So I want to start with a question that references something you mentioned earlier. The question reads, earlier you referred to a way that Justice Thomas was a bit different from his conservative peers on the court. Could you elaborate on that?
Oh yeah, I would say if Justice Thomas, if you're listening, please correct me if I'm wrong, but Justice Thomas seems to be the least persuaded by pragmatism. Thomas is the most strict originalist, and my evidence for this is the fascinating dissent that he wrote in the gay marriage case. While the majority opinion is filled with this incredibly moral language, I mean, Justice Kennedy just lets it all on the field in his decision. You know, liberty is about not dying alone. It's about knowing when you cry out in the dark, a loved one will be there. It's just this expansive understanding of liberty that he uses to support a fundamental right to marry. Justice Thomas has this very narrow dissent where he says, what does liberty mean? According to the people who wrote the Constitution, it meant being able to travel from one place to another unimpeded. Is this an issue of traveling unimpeded? No, right? And then he says, does the government give you dignity? Because Justice Kennedy's talking about the dignity of gay people and how their dignity is hampered by these laws criminalizing their love. Justice Thomas says, does the government give you dignity? No, God gives you dignity. Do not look to the government to give you dignity. This case is not about dignity. Done, right? There's no discussion of consequences. There's no discussion or engagement with the language of Kennedy's majority opinion. Thomas is different he's the sledgehammer of originalism. It is, a hammer to the face. He's not going to engage with like Scalia. Scalia is a rapier. He's dissecting language. He's trying to engage Kennedy, provoke him. So Thomas is a strict originalist. And I can guarantee you he is going to be on the fundamental right to concealed carry side of the gun rights case. And he is against the fundamental right to get an abortion in the abortion case. There's just pigs will be flying if Justice Thomas does not go on those sides. The apocalypse is happening. Run if Justice Thomas becomes a moral reader.
Great, thanks for clarifying. So let's get to some of these other questions. So this person writes, to what extent should fundamental rights change in a period of social duress? For example, the pandemic.
That's a great question. So I would say that in the first part of your question, I would say most constitutional law scholars would get a little, shivery, right? They would say fundamental rights don't change. That makes them fundamental, right? So the right doesn't change, but its scope and its meaning would. And so this is such a good question because it really gets at this issue that just because something is called a fundamental right, the conversation and the analysis does not stop, right? And this becomes an issue during a pandemic because certain things you would be allowed to do in normal times, you cannot do during a pandemic. We saw this when the government was shutting down places of worship, right? But allowing liquor stores to stay open. Now, you don't have a fundamental right to drink booze, right? But you do have a fundamental right to practice your religion. And so a number of Christian groups sued, but the court was hesitant to override these pandemic policies. They did sometimes, they didn't other times, because remember, even if you have a fundamental right, if the government can show a, quote, compelling interest and a law that is, quote, narrowly tailored to advance that interest, they can override your fundamental right. So the question before the court was, does the pandemic present a compelling interest, right? Does keeping people from gathering rise to the level of a compelling interest during a pandemic? If so, is this law narrowly tailored to achieve that compelling interest? And so even when a fundamental right is being implicated, the times in which we are living would set the parameters of what we would call a compelling interest and a narrowly tailored law. Once the pandemic is over, the government could not say you're not allowed to go to church, right? No matter what its reasoning is. But during a pandemic, the need to keep people from gathering becomes compelling. And that makes the court open to violating even a fundamental right.
I have a couple of questions that are similar, so let me read both and then let you answer. The first says, what does the individual owe to the social contract and vice versa? And then the second question is, why is it that an individual feels they come first and do not have any obligation to consider how their stand touches anyone else?
Yeah, United States, USA, US. I mean, this is the fundamental premise. This is the Kool-Aid we drink, right? This is the thing that makes us Americans. I swear it's the reason why we don't use the metric system. It's the reason we don't like soccer, right? We just won't. We won't, no matter how much you want us to. We are a people that in our, at least our conception of who we are, what makes us different is this fundamental, obsessive interest in protecting the rights of an individual. Your rights are given to you according to the Declaration by your creator, but they are your rights as an individual. They are your individual rights. And so in this particular country, your individual right will always trump the collective good unless your actions are so bad that we can overcome this barrier and say compelling interest. We are as a people obsessively interested in protecting the individual against the collective. And you can see this in the entire system of government. If you compare our system of government to a parliamentary system, our system moves slow. Our system does nothing rather than do something. In a parliamentary system, you are creating a system that aids and abets majorities to govern. Our system is designed to be anti-majoritarian, out of a really almost paranoid fear of the government intruding on your individual rights. And so the answer, unfortunately, if you would like to have a more collective society, is the individual owes almost nothing to the greater good, unless it's mandated by law. And that law is going to be challenged in the court if it is violating an individual's rights. And the court is going to be very skeptical, especially if that law is violating something we consider a fundamental right. Because you have the right to be a selfish crank. You have the right to be a horrible person in this country, way more than you do in other countries. You have the right to be a racist bigot, right? You can go out and scream obscenities. You have that right. And that's what makes our country very different from other countries, for better or for worse, depending on how you see our society now. And in many ways, we're experiencing the negative impact of that. I have the right to go on and spread misinformation about vaccines. I have that right. Now, Facebook can shut me down, but I can just find another way to put it out there. Whereas in other countries, for example, in Germany, it is illegal to deny the Holocaust. In the United States, I can do that. I can deny the Holocaust if I want to, and there's no law against that. So yeah, individual rights are sacrosanct in our country, and that is why the court tortures itself so much on this idea of fundamental rights, because the court is so nervous about, or at least we want to believe it's so nervous about violating those rights and becoming a legislative body that is now going to be a non-transparent, unaccountable law-giving body, as opposed to the kind of neutral refereeing that we hope it will be.
Okay, and just to follow up, we have a couple of questions that have come in around the issue of public health.
Yeah.
So let me read both of those and then let me know if you need me to repeat. But the first is, what are the issues around public health, the vaccine, in the context of this discussion, and should they be part of the conversation? And then another individual in the Q&A has said, what about community/public rights versus personal and individual rights, especially during these pandemic times, thinking about public health and various mandates?
Yeah, they're really great questions. Really good questions. So I hope no one thinks I'm punting on this, but I'm going to do a move that might seem like a bit of a punt. One of the big issues here comes down to what is the jurisdiction of the court versus what is the jurisdiction of the legislative branch, right? And so if I am trying to answer that and I'm trying to be sympathetic to the court, the way I would frame my answer is by saying the courts are not there to tell you what is in the interest of the community, right? They are not a legislative body. They were not elected by you. They are not accountable to you. They are, in fact, completely separated from you by many layers. I mean, it is you, your presidential vote, the electoral college, presidential nomination, Senate confirmation, Supreme Court justice. I mean, they are as far away from you as you could possibly be. And so my answer would be, you don't want the courts to be determining what is in the public interest. They're not responsible to you. They're not accountable to you. So you would not want them making those determinations. Congress should be making those determinations. Congress should be telling us what's in the public good. And as long as they're not violating constitutional rights, they're fine to do so. The reason why the court is so prominent right now is because our Congress is dysfunctional. And I will be the first to tell you it is. And it is dysfunctional for many reasons, but the single most cancerous thing going on in the courts and the Congress right now is our method of voting. It is our gerrymandered districts that create extremism. If there's just one thing we could do, it would be, altering the drawing of electoral districts. But I'm going to quote the eminent sage Don Rumsfeld: you go to war with the army you have, not the army you want. We're going to go into this court term with the Congress we have and not the Congress we want. And the Congress we have right now is dysfunctional. So we're looking to the court to do this work. We're like, oh, come on, Supreme Court, tell us how to keep each other safe. And I think it is a dangerous thing, because that court might tell you things you don't like. It might restrict rights that you would like to see protected, and you have no way of resisting. You can't throw the bums out on the court. They're non-transparent, they're not accountable. And so I think that's the issue, that Congress is supposed to be the branch that responds to the public interest and that is attempting to advance the common good, right? Though I have a problem with that phrase. I don't really think it exists. I think Congress is there to advance what their voters believe is the good. And the court is there to protect the core rights of the Constitution. And those core rights are individual rights. There are no group rights protected in the Constitution. And I think, well, with the possible exception of whether you are in a, quote, distinct and insular minority. And there, it's not really a special right that you have as a Black person, as a gay person. It's the fact that you are getting treated poorly by the government and you need to have your basic rights protected. But you need extra scrutiny, you need extra help because you are facing a hostile majority. So even there, it's not a group right. It is instead extra protection that the court will grant you if a law is impacting you. So I think that might be the issue, that we want, I think right now with a dysfunctional Congress, we look to other branches to fix things. And I have a big problem with progressives right now saying that Joe Biden should just start doing things by executive order. I had a problem last year when conservatives were saying Donald Trump should just do things by executive order. I think that is a dangerous path. It's the path of least resistance now, right? But if you are okay with Joe Biden doing this, are you okay with Donald Trump doing it? Probably not. And so I think we are constantly looking for someone else to save us from our dysfunctional Congress. And I think the courts are the wrong place to look.
So we have a couple of questions back to the topic of abortion. If Roe v. Wade is either overturned or allowed to be limited to the point of almost non-existence, what can we do to maintain women's rights to their bodies?
Yeah, not much, unfortunately. I mean, not much. So what I don't want to be glib about this, but I need to be realistic. So if Roe were overturned, or if Roe were curtailed to the point where states could essentially get rid of it without getting rid of it, what would it mean? Well, we would go back to a pre-Roe America. And in a pre-Roe America, every state had its own set of restrictions. So I want to emphasize this, right? Because we are tempted to say that this is a question about when does life begin? It's not. It's not, right? Because if this was a question about when does life begin, conservatives would not be okay with every state determining abortion policy. They would be pushing for a complete federal constitutional ban on all abortions, right? So the fact that a right to life activist is saying, oh, well, states should make that determination. Well, if they believe that life begins at conception, are they okay with the state of Vermont murdering? Right? So it really shows that this isn't really so much about when does life begin. It really is about who gets to make this decision, and at what point do you get to make that decision, and what role does the larger community have in making this decision. So what would this look like? This would look like a pre-Roe era. So what would we, those who are for a woman's right to choose, what could you do? Well, you would have to focus on your state legislature, because it would be a state by state patchwork of where are these rights protected and where are these rights not protected. And this is going to immediately impact the poor, right? Wealthy women can just travel to another state. They already are. Wealthy women in Texas are traveling to Oklahoma and Kansas to get abortions. Reports from doctors that give abortion care say up to 80% of their patients right now in Oklahoma are from Texas. But you need to have a car or a plane ticket. And so that's the issue. The issue becomes for women who are not able to leave their state. What could they do in this situation? All you can do is vote accordingly in your state legislature, because that would now be the body that's determining what this right looks like. I hate to be so negative, but in a overturned Roe scenario, every state has the right to figure out what abortion rights look like in that state.
Another attendee asks, could you explain a bit more clearly how the new Texas abortion law tried to avoid a Supreme Court case?
No.
The business about private citizens bringing suit against abortion providers.
Yeah, oh my gosh, I'm gonna try. I mean, this is such a novel approach. Okay, so typically a court cannot intervene unless there is an actual case, right? We need to have a victim. Someone needs to be harmed by a law. All right. And then what happens is the courts stop the state officials from enforcing the law. So, for example, in a traditional abortion ban, right, I, as a woman that wants to get an abortion, would sue the attorney general of the state, because that is technically the person who would be enforcing the law. I have a person I can sue. You, as the attorney general of Texas, I'm going to stop you from enforcing this law. All right. But what happens if there's no one you can sue? Right? That's the question. And so what they did in Texas is they specifically stated in the law that no official of the Texas government can enforce this law, right? And you cannot sue the woman trying to get an abortion, because then you would have a clear victim of the law. So instead, private citizens are taking other private citizens into state court to sue them for punitive damages. Okay, if you want to overturn this law, who do you file suit against? Every single citizen of the state of Texas, right? You can't sue any government official. They are specifically not allowed to enforce the law. You can't sue the judges. There's no case in front of them. You can't stop them from hearing a case that doesn't exist. You can't sue every citizen of Texas. So there's no one to sue. So this is the novel. If you are on the pro-life side of things, maybe you would say innovative. I mean, it is clever, because it has allowed this law to go into effect, because the Supreme Court said, right, looks like we can't intervene because there's no one to sue. And a federal government cannot sue a state. You can't stop a state from enforcing the law. You have to sue an individual who is charged with enforcing the law. And there is no clear individual charged with enforcing this law. But here's the danger. The danger is that same innovation could be used to restrict any right, right? What's stopping the state of California from saying, as a private citizen, if you see someone aiding and abetting the purchasing of an assault rifle, right, you can sue them, and no government authority can enforce this law. Well, now all of a sudden your right to have certain kinds of weapons, or let's say a firearm, a handgun, they could say anyone that tries to buy a handgun, right, can be sued by a private citizen, even if you communicate to them and drive them to the gun show. Well, now all of a sudden your Second Amendment right is null and void, and there's no one to sue. I'm firmly believing the court is going to just uproot this novelty because it really threatens every single right in the Constitution. If they can do this to the right to abortion, they can do this to speech rights. They can do this to the right to exercise religion. They can use this to the right to bear arms. You pick your right, and they could get around it through this mechanism. And that's my best attempt at explaining it. It essentially is designed to make sure there is no one to sue. And if there's no one to sue, you can't stop the law from going into effect. And they were successful. The law has been in effect now for 2 months. And so in that sense, it was successful.
Okay, thanks, Eric. We're nearing 7:30, but I'll just get in one more question. We still have a good number of folks online with us. So let's try to get to one more question before we wrap it up. Given the evidence of systemic inequalities in our economic, educational, and healthcare systems, should the Constitution be revised to include an obligation for lawmakers to incorporate the unequal impact of laws on individuals? For example, the impact of Texas Law SB 8 on the poor.
Yeah, that's a great question. That's a fantastic question. Our Constitution is pretty terrible at this. Our system of government is pretty terrible at this. And I want to just briefly explain what I mean by that. Our system of government is built around self-interested majorities acting to protect their own self-interest. Our entire system of government is designed to do this. Really, all democracy is designed to do this. Our system of government outlined in the Constitution, what does it do? It identifies and channels the energies of self-interested majorities. And so how do I get a law passed? I have to get a majority of the members of the House who are representing their districts to agree. Then I have to get 60% of the Senate to agree, all representing their districts. Then I got to get the president to agree, representing a different electoral district. But I have to get all of them to see this law as in their self-interest. Well, why is that a problem? It becomes a problem when the issue is protecting the rights of minorities, right? Because it's not necessarily in my self-interest as a member of the majority to extend protections to a member of the minority. And so this is something that has plagued the court, and it has plagued our country. If you look at the long history of civil rights and trying to get equality for Black Americans, it is incredibly difficult to convince a white majority to extend protections to the Black minority. It is incredibly difficult to convince the straight majority to extend protections to the gay minority. I mean, this is as old as democracy. And so how does the court try to do this? The court tries to do this by protecting certain identities, by explicitly saying this identity is a protected identity that is subject to this higher level of scrutiny. And so, for example, race is one of those identities. If you have a law that disproportionately impacts Black Americans, that law will be subjected to the higher test of strict scrutiny. If you have a law that is directed at women, that is an identity that gets higher scrutiny, not strict scrutiny, but this thing called intermediate scrutiny. But here comes the problem. The problem is, what if you are a member of an identity that the court doesn't believe is worthy of this heightened scrutiny? Well, then you're out of luck. And being poor is one of those identities. The court has explicitly stated time and again that being poor, poverty, is not a protected status. So if you have a law that disproportionately impacts the poor, you do not get the heightened scrutiny that you would if it was a law that targets you based on your race or your gender or your sex. And so we are a country that does not do much to protect the rights and living conditions of poor people. And again, that really comes down to the story we tell ourselves of who we are and how we came to be. You as a poor person do not have rights, any kind of protected status, and there is very little interest in codifying those rights in the Constitution. There's very little interest in even protecting those rights in the Congress. Even the Democrats can't decide about how to help the condition of the very poor. They're fighting with, they don't even need Republicans to be dysfunctional at this point. And so that is just a big giant blind spot in our country. And I don't see the way out of it without a complete overhaul.
Great. Well, time has run out, but I want to thank you so much, Eric, for taking time out of your evening to share your thoughts and insights with us today, and for leading such a stimulating and important discussion about a lot of complex issues here. I really want to thank as well all of you in our audience for taking time to join us this evening. We hope that you will watch your email inbox for future announcements about events coming up by Zoom, and hopefully soon we'll be able to get some of you back on campus. Eric, we're getting a lot of really positive comments about your session this evening from members of the audience in the chat. So thanks again, everyone, and have a good evening. Good night.
Thank you so much.